just tell you, let's go on to the first slide, please, and we'll move on forward from here, and we'll get started because there's a good chunk of you already here, and I want to honor the fact that you're on time. So if we could please advance the screen to a couple of slides. So one more, please. One more. Oh, there. So stop there. So go back real quick. So what we're going to do from now on is we have a ton of newsletters. I just approved one yesterday that Connie will get early next week, and it has to do with the cases I'm going to talk about today. But we also have the newsletters on the recent laws and all that. So rather than make you guys search, we're gonna make it available to you. And actually, what we talked about the other day to make it even easier is we're going to start putting up a QR code so you can literally scan any newsletter you want into your and take a look at whatever you want. Mass, please mute yourself, and that goes for anybody else, please. All right, so let's go to the next slide. I'll tell you what we're going to talk about today. Let's move. Okay, there we go. So in December, we all got these new buyer broker forms, and I've done a couple of things now, both with and without brokers. And so I want to take a closer look. I've had some conversations, and I'm actually going to do not a brown bag, but a legal panel next week with Neil, who wrote these forms. And so I want to take a closer look. Also, there's been some questions about the revised RPA. So want to touch on that. We're going to talk about all the other new forms, both revised and the new ones separately, because really I want to talk about the buyer representation forms in and of themselves. I got a copy of the drafts of the forms that are coming out in June, and I'm just going to tell you what they are. Obviously, as we move forward, we'll go over them. But as of right now, there's only one new form, and they're going to revise a bunch of forms. Let's go to the next slide, please. We're going to talk about some new laws. I will tell you that I'm going to go over that very, very quickly because we wrote a newsletter, and there's an expanded courtside newsletter regarding all the new laws that we thought were important. There is something very important. The board handles disputes amongst yourselves whenever there's a commission argument. If Lisa thinks that she's entitled to the commission, but Susan thinks that she's entitled to the commission, by the code of ethics and the MLS rules, those come here. And whenever it's an arbitration over money, the panel that's going to hear the case uses what we call procuring cause guidelines. And those changed dramatically on December the 19th. And so I want to go over those with you because they emphasize the new buyer broker forms much, much more than they ever have before. I'm going to give you a little brief update on the MLS. I talked to Ed Zorn yesterday, and a couple of things that have come up. Ed's your attorney at CRMLS, and so we'll go over that. Then, some trending liability issues. We're starting to see what we knew we were going to see, which is statistics showed that about 60% of buyers over the last year or two were not happy. And unhappy buyers equal complaints and lawsuits. So we're going to talk about that and some other trends that are coming up, and then we'll have a Q&A. I haven't scheduled anything this afternoon, so I'll stay as long as you want. Well, at least a half hour over the scheduled time. So we'll do that. So let's take a look at a couple of issues relating to the. Now I'm going to guess, I'm going to hope and pray. By now, again, I'm preaching to the choir here because this is the group that comes to things like this, right? And most of you have probably read, studied, digest it as much as you can, the new BRBC form, which is the Buyer Representation Compensation Agreement. And so I'm hoping that you had some reasonable familiarity with it. So I want to talk to you about some of the things that we've been talking about and that we've been seeing. So let's go to the next slide, please. And unfortunately, when I wrote this, I didn't put it in any necessarily good order. My mistake, not anybody else's. So the first question that has been coming in is, when should you do the buyer broker representation agreement that just came out? First of all, for backdrop, for those of you that don't know, they took all three forms that were available on December the 18th, and they combined them into one form. So there's no longer an exclusive buyer form. There's no longer a non-exclusive. It's all one form. And so the issue really is, and one of the reasons they haven't made it mandatory yet, is there's a question, when should you get them signed? Either before you start showing or before you write up your first offer. We all know that the agency disclosure form has to be given, quote unquote, no later than when you write up an offer. But that probably isn't when the legal obligations that you have to prospective purchasers actually start. Although there's no set rule, I want you guys to understand that. Most of us believe that the earlier you can get this buyer representation form signed, the better off you're going to be. And I'm going to show you that when I actually put the form up. Number two, the form and several other places now actually kind of define what it means to be involved in a property. And that's significant when you get to the argument over who's entitled to the commission. Broker involved means that you've actually shown the property, not simply sent me a bunch of videos or other things that I search on my own. It means that you've actually gone into the property or have virtually entered the property. It means that maybe you wrote up an offer. These are, by the way, or, these aren't and. So these are not collectively, these are individual. So number one, you have to establish minimally that you went into the property either virtually or physically, or that you wrote up an offer, whether it was accepted or not. And then lastly, that you substantially introduced the client to the property and provided, relevant information. That's defined now actually in the broker representation agreement, as well as in a couple of other forms. So if you have a written agreement and if you were involved in introducing this property to the buyer, you've taken some pretty good steps towards claiming that you are the procuring cause, as I'll show you later. Be careful when you fill out compensation, because they've given you lots of new kind of ways. And this is an area where we had a meeting with your professional standards people a couple of weeks ago, and I made the comment, and I'll make it again today, you need to be patient with yourselves. You need to be patient with others, because a lot of this is being introduced into the marketplace, right? Traditionally, it's been whatever the MLS offered. Maybe you work out something with your buyer to pay a little bit more than a particular number. But now you're being given rights to charge flat fees. You can charge what's in the MLS plus in a different amount. The other day, I had a case that we had to get resolved before the close of escrow, because the buyer's broker had wanted to be paid a $10,000 bonus because of some additional work he had to do for this particular buyer, but he filled it out incorrectly. And so now you run the risk of not being able to be compensated. So again, when I show you that particular section, be cautious. How long should it last? I was in California a couple of weeks ago, spoke at about 5 or 6 associations, and everybody seemed to agree they didn't have heartburn with 120 days, right? Where if you're going to show the property over a period of time, anything over 120 days, they start feeling maybe that's a little too long. but if you could, get 90 to 120 days, probably going to be okay, at least as far as ethical standards are. Now, we don't have a case. We don't know for sure, but the consensus amongst the professional standards people was that. Remember, there's a bunch of other forms that go along with this form. There's the agency disclosure, which you must have. There is an anticipated broker compensation agreement, which you must fill out along the way. There's some other documents. You're also bundled with the fair housing, advisory, with the privacy advisory, with the competition, more than one buyer or seller. So all those forms go along and discuss. But before you get a client to sign this, you need to remember that it is your obligation to explain these forms to the client. Don't just send it over and then get a DocuSign in 10 minutes. You have to go over these forms like any other form with your clients. How you do that is obviously your personal skill, your personal your personal choice. One of the things that we did talk about with a group of brokers is it's a great time to let the client know why you're doing this. We hear a lot that, I don't want to use a buyer representation form because the client will go somewhere else. Well, that's only because there's somewhere else to go. But if everybody starts using this form, if you carefully explain, look, the form is important because it's going to define what I'm going to be paid. It's important because it's going to define what I'm going to do for you. It's going to be important because it's going to describe what your responsibilities are. And real estate documents, by their very nature, should be in writing. Again, it's how you approach these things. But you got to at least explain these things. Article 9 does say any agreement that you have signed by your client needs to be in writing. And of course, there's no less duty to go over this kind of a form. And standard practice 9.2 says that if you send something via electronic means for signature coming back, you still have the obligation to not abdicate your obligation. Keep track of your showings. Now, there's various ways people, that have been around for a while, that are the veterans, probably have various ways of keeping track of what you've shown. I have my best friends who are looking to move here, and I drove around a couple of weeks ago looking at property with the realtors that I've been using and referring cases to. And what he did is he downloaded the little MLS, and then he wrote notes on the MLS data sheet, wrote notes on the back. There's a form. Some people use cards. There's lots of different ways you can do it, but you got to keep track of your showings, because if you don't show the property the buyer actually purchases, you're not going to get paid anything, right? But if you've shown that property, then you keep track of it, because at some juncture, I'm going to show you the form you're going to want to send to your client. Next slide, please. Stay in communication with your clients. One of the things we've been talking about and I've been seeing is, you lose track of your client. You show them a few properties and then you stop communicating. And that is the number one reason that clients will move on, unless they're lured or there's some unethical behavior. Make sure you understand that are there any other pre-existing agreements? Because if there are pre-existing agreements, you may do a lot of work and never see a dime. If there's an exclusive representation agreement, if there's a buyer representation agreement, you may end up writing up the offer, closing the deal, and never seeing a dime, because the other broker who has a pre-existing agreement is going to be able to persuade whoever is hearing the case that they're entitled to the pot of gold. Not only that, but it has been made very clear to us now, and this is absolutely ironclad, that it is a duty of an agent to ask whether or not the buyer is working with someone else. And if they come back in the affirmative, yes, we are working with someone else, then you have an obligation to ask a couple of more questions. What kind of, have you signed a contract with these people? If so, what kind of a contract? Is it exclusive? May I see it? What's the name? Can I call Joe and talk to him about what his perception is? Again, if you don't do that, then you run the risk of doing a lot of work for no money. Angelica, can you mute yourself, please? You want to find out, obviously, is the contract that's been signed exclusive? Because if it is, not only will you not get paid, but you may commit an ethical violation under Article 16, which is to not interfere with the exclusive representation of another real estate professional. Then, of course, make sure you're transparent in your commissions. The days of buyers not knowing what the agents are making is gone. It's gone because of a settlement with the Department of Justice. It's gone because of the change of the MLS rules. Commissions are now very transparent. And you know what? That's the right way to be, right? Think about that. Lisa, would you hire a lawyer and not know what they're going to be paid? Of course you wouldn't. Would you, if you had to cover some medical procedure on your own, would you not want an estimate of what those costs are going to be? Would you buy a car without a sticker? Would you buy anything at the supermarket or anywhere else without knowing what you're going to pay, right? It's a part of the cost of the house, and it is no longer considered private. Be aware of the cancellation rights in the contract and how parties can cancel these agreements. And what I like about this contract and one of the bundled forms is that it explains fully what you are and are not fully, maybe not fully, but very well what you are and are not going to do. So I was telling Connie and some of the other directors that when I first purchased my property here in Tennessee, I got a buyer broker representation agreement, and there was no discussion about whether I was going to sign it. It was, I was going to sign it and then they'll get started, right? Why? Because they wanted me to understand, which I did, but again, this holds true for all their clients. They wanted me to understand what they're going to do for me and what the limitations are. And isn't that important? Isn't that something that should be in writing? Look, I'm not going to go off-site. I'm not going to do this. I'm not qualified in certain capacities to do certain things for you. And then, of course, develop your own sense of best practices. As we move through the year, you know, we're going to hear more and more about things people do. What do the Barbara Harans do? What do the Lisa Neugebauers do? What are the people that do this job well, the Joe McGowan's? What do they do? What are the best practices? And we're going to start plagiarizing them, and we're going to have some things that we'll put in newsletters or whatever Connie, however she wants me to communicate. I am going to be coming in live and in person. We're going to be setting those dates pretty soon, and we'll hopefully do a few programs out in Southwest. That is my home board, and we'll kind of go over this stuff. Maybe the next brown bag, kind of bring you all up to date on what people are doing and what these best practices are. Let's put the form up, please. Okay, again, I don't know if you can read it, but the form, if you just walk through it, you know, obviously, and I'm going to just dig mine out because I don't know about you guys, I can't read that thing for squat. So mine is well written on. So a couple of things. Number one, it confirms who we're talking about and how long, and it's done in days. It's not done by a certain date. So you're going to put 90 days, 120 days, from whatever the date is of the agreement, the names of the parties, the names of the agents, that there are no pre-existing conditions. And then you're going to make a choice. If you're doing this kind of late in the game, do you have a specific location in mind? For example, you know, 123 Elm Street in Wildomar. Okay, that's fine. Or more than likely, it's going to be the following properties, in which case you might attach the broker involved properties or some other document. When it comes to other kinds of locations where boxes are to be checked off, the city or the county. And one of the things, and I've talked to CAR about this as well, because it occurred to myself, it occurred to some of you, that you don't put in, you know, Southern California, right? Be specific. Where are you showing? Are you going to be showing in Southwest Riverside County, which has be specific, because again, you're gonna want this contract to be enforceable. And if it's too broad, too ambiguous, then you're gonna have a hard time. Same with purchase price, right? If I go in and I say, Vanessa, I'd like you to help me buy a property, and here's my price range. I'm okay, obviously with the property at this range, and I can go as high as this range, right? That's the agreement. That's what I want her to help me. And so maybe, stay very close to that. But if you put $1 to 15 million, you're going to have a hard time enforcing this contract. So be very careful about that. And then agree, what is my compensation going to be? If you work for 2%, you work for 2.5%, that's pretty clear. And of course, what that means is that the tail end, there may not necessarily be any additional monies that have to come out of anybody. But if the MLS offer is less than what you're willing to work for, at some juncture, either the seller or the buyer going to have to make up the difference, or you're going to have to be willing to take less. I just saw Adam put up a thing that we're going to be sending this out. So I want everybody to understand, it's on the face page, that I am speaking of my own opinion at a high level, at what I perceive to be a high level of performance by realtors. It is not necessarily the standard of care. This is not necessarily legal advice, blah, 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 blah. Okay. So I don't have a problem with recording it. I wouldn't send it out to anybody that wasn't registered and who's here, because why should you give it to people that are lazy? Then again, there's cancellation. You can either say it's cancelable immediately if it's non-exclusive, or if it's exclusive, 30 days. And so I forgot to mention, there is a box for exclusivity, right? And you need to make sure that the buyer understands that means that if I sign a contract with Vanessa and she checks off the box that says exclusive, that means if I buy any property in the Temecula Valley within the ranges we've agreed to, she's getting paid. Okay, this is the flip side of the exclusive right to sell. That, and again, it used to be its own form. Now it's just a box and one paragraph. Okay, there's an accounting paragraph. There is a paragraph for when you get paid. It's going to usually be at the close of escrow, but if the buyer is interfering in some way and prevents the legitimate closing, just like on the listing agreement, there may be a right to compensation. It confirms agency disclosure because you're going to have them sign an agency disclosure form. So again, this is a really big topic in the liability world, and that is, when does the representation, that agency principal representation, start, right? If I go in to Lisa and I say, Lisa, I'm interested in purchasing a property. I hear you do a pretty good job, blah, blah, blah. Or Lisa persuades me that I should sign with her, and we're going to do a buyer broker representation before we even hit the road, which is perfectly okay. Then at that point, she's going to give me an agency disclosure, and we have commenced an agency principal relationship, right? So those two forms go hand in hand, and it is bundled, right? And if I were you, and I'm not, but if I were you, I would take a little while and maybe reread, or for some of you, pardon me, read the agency disclosure form. It is a mandatory form if you want to be paid. Then there's a little section on broker authorizations and obligations. There's a section on the buyer's obligations to act in good faith. Excuse me. Apparently, you're not supposed to wear shorts when it's 45 degrees. I am learning that the hard way. So personal financial information and all that. There's an attorney's fees clause. So if you have to go after the buyer for your fees, you will be entitled to attorney's fees. There is an alternative dispute section, and then the boilerplate at the back. So again, a couple of quick comments. Well, go to the next slide. I think we're going to go back 3 slides up. Go 2 at least, please. While he's doing that. This form there was a lot of debate at CAR. Some of you attended those meetings where the discussion was, should we make the form mandatory? Adam knows this better than anyone. You don't want to take anything to this particular legislature. So the only way to make it legally mandatory would be to get the legislature to amend the code in some fashion. It's probably 1624 of the Civil Code, which is the statute of frauds, and make these representation agreements mandatory. Nobody really wants to do that in California right now. So the second step is to make it a standard of care that says if you don't have a form, so either NAR or CAR would say this, and they're pushing it towards that by creating the new procuring cost guidelines. A lot of that is being done. So is the form mandatory? No. Is it mandatory? Maybe. Is it something you really ought to think about doing as often as you can? You betcha. You betcha. If you were talking to Ed Zorn right now, or me, or a bunch of you that I've talked to about this, we all agree it should be mandatory. If you look at Article 9 of the Code of Ethics, which is your anticipated behavior. I'm going to say that to the boys and girls tomorrow morning. It is your anticipated behavior. It is what you're expected to behave. It says very clearly that all agreements, including but not limited to listing agreements, purchase agreements, leases, representation agreements, should be in writing, signed by the client. Okay? So you pick. Next slide, please. So there are some misconceptions. Like I said, it's not mandatory, but we're sure headed that way. We still have offers of compensation in the MLS, but again, they're all negotiable. But again, talking to Ed, who's your CRMLS attorney, probably one of the finest attorneys in the nation in terms of MLS, you're going to hear him say he doesn't think compensation in the MLS will be around 2 years from now. Film at 11 on that one, but take a word for the wise. It's still negotiable. It is, if we're going to talk in a second about the new RPA where the seller pays, that's not a violation of Article 16, and offering compensation in the MLS is still the rule today. That may change over the next couple of years. There's CAR has a really good little form. It's called Misconceptions. Type in CAR and go to Quick Guides, and it's there, and it's 1 page long. It's pretty good. They did a good job. All right, next slide, please. Some other forms that go along with this form. This is the anticipated broker compensation disclosure form. And this is the form that as you show properties, you're going to put in there what the anticipated compensation will be, because that's going to be part of the purchase price, right? You're going to roll the compensation the seller is paying to their agent and that you're getting. And so this goes on. Goes along with as you show properties. One of the things I wish they would have done, and I'm going to talk to Neil about it next Thursday when I'm on a legal panel with him, is numbering these things so that let's say who have I picked on? I haven't picked on Joe. How you doing, Joe? Good to see you. So Joe shows me 3 or 4 properties, right? I get one of these forms. And then the next time we go out, I get another one. However it looks, but most of them are going to be what's offered in the MLS, right? Joe's willing to take 2.5%. That's what it's going to be. 2.5% equates to how much? And then if you look at the second half, it confirms once we pick and get an offer accepted, this is going to be my compensation, right? Because this way you've got your file properly documented on a very important aspect of the transaction. Let's go to the next slide, please. I love this form. I love this form. Even if your client is unwilling to sign a buyer representation form, give them this form. This is the buyer transactional advisory form. It is bundled with the BRBC, but if for some reason it's not going to be used, what this form does is it lays out very clearly what is and what is not going to be done. It's just a good little advisory so that your buyer can't claim, well, Susan told me she was going to do this, right? This is the form, and then this plus documenting your file along the way gives you a lot of protection from the buyer, who is statistically the most likely plaintiff in a lawsuit after the close of escrow. Next slide, please. This is the cancellation form. And again, this is the form that can be signed by you, right? I'm working with Lisa. Lisa's tired of my nonsense, so she cancels, right? She gives me the broker involved properties she's shown me, but she's done with me as an agent, right? Remember, the canceling a principal agency relationship can be done at any time, so long as the principal is not prejudiced in some way. And so people can fire me anytime they want. They can fire you pretty much anytime they want, but that doesn't mean they're not required to pay what I've already earned or what you've already earned. So again, this form helps you to document the cancellation. It's not going to get used all the time, because if they just walk away from you, right, and you don't even know that they've gone to another broker, you may not have the opportunity to use this form. We did a hypothetical with the professional standards people. So, but again, to properly document your file is a pretty good form that talks about what you anticipate compensation or what they anticipate compensation. And again, it can be a period of days immediately if it's a non-exclusive, or it could be 30 days if it's exclusive, but it doesn't get them off the hook if you've already been the procuring cause of that transaction. And that's what I'm trying to get across to you guys. You can still get paid. You can still, I hear it all the time. How can I say this? Well, Billy Bob says, I think it was Billy Bob in Talladega Nights, that if I say with all due respect, I can say anything I want, right? So with all due respect, if you get screwed out of a commission where you've worked hard for a buyer and you don't do the things that they're now giving you the ability to do, don't whine. Don't whine. It's your fault, right? You're the professional. You got to protect yourself, because you've probably heard this. Lisa, you probably maybe even had one. Buyers lie. Buyers are the culprits, right? And so Debbie, it's not funny, Debbie. Yes, it is. It's hilarious. But the fact is you got to protect yourselves, right? I have engagement letters, right? My clients generally like me and we do a pretty good job, but you know, there every now and then over the last 46 years, you have somebody that's a jerk, right? The more you can document, the better off you're going to be protected. But you can't document everything. Some things are going to come up, but you can document cancellation because I quit. I don't want to be your agent anymore, or I don't want you to be my agent, but that still doesn't get you out of getting paid. Next slide, please. Keep going. That was a 2-pager. I should have just put up the face page of each of these, but in case any questions come up. Now, this is something you have to give to your buyer within 5 days. This is that safe harbor kind of a thing. You need to provide it to them. And these are the properties you've shown them, right? And by showing them, I mean where you were involved. You can't put down, well, here's 100 videos. Go ahead and look at them. We are talking about properties that you entered, properties that you entered either physically or virtually. These are properties for which you wrote up an offer, or at least discussed the preparation of an offer, and or where you provided substantial information, even to the point of introducing the particular property. And again, if you look at paragraph 4, it defines broker involved properties, and then you give them the list. You can do it via an attached document. You can do it however is comfortable for you, so long as it's thorough. Then if you notice in paragraph 5, there's a strong recommendation that they notify the next broker. So if I've worked with Michael and Michael provides me with this form, and I now go to Barbara, right? Barbara now is given this form. Hey, Barbara, I just want to make sure you know that Michael is, I've been working with Michael, and these are the properties he's shown. Because now it's incumbent upon Barbara, hey, pick up the phone, talk to Michael and find out Can I pay you a referral fee? Did you do enough? You know, where are we at? Because you don't want to be in a situation. We had this, I think I told you guys about this about 2 years ago. I had an arbitration. The purchase price was $45 million. The buyer side of compensation was $900,000. The agent who wrote up the offer and closed the deal didn't get 1 cent. Right? This is real. This is real. So you got to protect yourself. So that form came out on December 19th of 2022. Next form, police. All right, and this is a form I really should have put after the RPA. So here's the deal. Will it be a tracking nightmare? I don't think so. Right? You guys track all. Somebody just asked the question. I'm going to, by the way, go through all these questions. So be patient. My way of making you stick around to the bitter end. But this form here is really to be used very rarely and with the RPA. They modified the RPA on December the 19th. And there's now a paragraph 3G3. It's referenced in the matrix and it's referenced in the body of the document. And it's new, just came out in December. It's to be used very rarely. So listen to me. Only when the seller has agreed to pay the difference between what they are offering and what the buyer and the broker have agreed will be compensation. So let's say that I have a buyer-broker agreement with Debbie, okay? And it says that I'm going to be, the buyer is going to guarantee me 2.5%. And the offer in the MLS is 2%. So we're going to ask the seller to pay an additional 0.5% so it doesn't have to come out of my pocket. And then the seller can agree. And in this market, you may have a better luck than you might have when you had 64 offers to consider. Or they can counter it out. But again, so what you're going to want to do, and this is a tip I got from about 5 or 6 other brokers. Number one, when you send the seller payment to buyer's broker form as part of the offer, so you're going to have checked off the box, fill out this form, send the buyer representation agreement with it, because you can't use this form if you don't have a buyer representation agreement. So like I said, it's a relatively narrow time when you're going to use this. We've seen a lot of people checking off boxes lately that don't know what they're doing, you know, which is why I get to go on a lot of cruises every year. The fact remains, it's a very narrow situation. Number one, you're asking the seller to pay some form of compensation to the buyer. So the buyer's broker, so the buyer doesn't have to. Number two, you have a BRBC, and then you might want to consider sending it to them to prove. Because, right, if I'm Barbara, I'm sharp. I got a listing. I've got this thing in here. Well, I want proof that you really have a contract for 2.5%. Then I can go to my seller and say, yeah, they really do. And now what do you want to do? Or here's my suggestion. We can counter, we can do this, we can do that. That's the way the negotiation will take place. Next slide, please. So that's it. That's it. And I've got 16 questions. Maybe they're questions, maybe they're just wear a nicer shirt or something. I don't know. Let's look. I'm going to go back up to the top. So the sun will come out tomorrow. Yes, I know. At least here in Tennessee it will. Hello, I would like to run a property management issue by you. No problem. You can call me afterwards. So I'll give you my phone number. Well, I'll give it to you now. Write it down. This is my cell phone, and I am not a hotline. So don't call me expecting free legal advice. I'll do it today because Connie's been nice to me. 951-310-9055. Or what would be easier is to, if it can be, is to email me your question and I'll send you back a response. Yeah, Adam is putting all this on recording. The buyer representation is to buyers as the listing agreement is to sellers. That is actually, Shauna, that's actually a correct statement. If it's exclusive, right? You have an exclusive listing agreement. You also now have an exclusive buyer representation agreement. Can we get a copy of this? Yes. Would I please address what? I don't, Joe, it just says here, would I please address? I don't have anything else, or do I? No. So tell me what you want. You can unmute yourself and I'll answer your question. Just let me go through the rest of these. I don't know about, I don't have anything to do with the Zoom part. At the top of your screen, okay, that's not a question. Does agent and COBRC, if you're talking about the BRBC, yes, they both, well, you have a contract only when all parties execute it. If the cancellation is mutual, no, you can, that's a great question. You can waive the 30 days if you just want to get rid of each other. Am I missing something, or will this be a tracking nightmare? It won't be a nightmare if you develop a process to do it, but it's certainly worth doing if you're going to get a $25,000 commission or protect a $25,000 commission. At least that's my opinion. Add the broker involved property form to your transaction and zip form. Yeah, however you guys do this, create your own template. Just be sure that you make sure you periodically check to see what's being revised. And then off subject, is there a change to the TDS? Yes, I'm going to show it to you in a little while. There will be a change to the TDS in June. Somebody, Lisa, you have advanced information. Good girl. All right, Joe, unmute yourself if you still want to ask your question. I don't see Joe anymore. He's taken off. All right, so I'm just going to run through these real quickly. There've been some cleanup language. There's now a no default provision for points. Let's go to the next slide. This is the 3GE slide, 3G3 slide, excuse me. And again, I've talked about this. There's an agreement that the units that a buyer intends to occupy will be vacant. In your area, not as big a problem. If I do this up in LA, huge problem, because the only person that can actually evict a tenant is the buyer, is an owner who intends to occupy. Well, the seller who's selling is not intending to occupy, and the buyer who's buying is not the owner until they close escrow. Much, much different problem in Los Angeles County than what you guys have. So keep Adam well funded so he can keep the local city councils at bay, because otherwise you got yourselves a nice nightmare on your hands. Again, just to remind you that CAR is recommending that if there is an occupant in the property, whether they intend to go or not, then you provide a TOPA form, and if the person is on title or not on title, again, if those people that are not on title need to be covered by these forms, that's a subject for another day. But just be aware, CAR does recommend you use the TOPA form whenever the property is occupied by someone who is not the owner. And that can be anybody who's off title, okay? All right, next slide, please. Yeah, this is just the paragraph that talks about unit buyer to occupy to be vacant, and then the buyer will designate which unit they do intend to occupy. Of course, that presupposes that there's going to be a multi-tenant project. All right, let me see here. Next slide, please. I want to get through these rest of these forms. Now, we have finally settled the long debated issue of are rods and associated hardware included as fixtures. The definitive answer is yes, and it is now in the contract. Okay, so just be aware that we will no longer argue about rods and all the other window covering stuff. Okay, it's fixtures. Next slide, please. There is now, and I'm going to show it to you in a second, a solar advisory and questionnaire. that you will use only when there is solar at the property. Okay. And then they've provided a little more clarity on this investigation issue, so that a buyer's investigation of property matters affecting the property includes certain documents. I actually saw an $800,000 transaction, which here in Tennessee is a good number, particularly out in the rural area, canceled because they never provided engineering and grading reports. So you got to have that stuff ready to provide within 7 days after acceptance. They've cleaned up that language a little bit. And there's a whole bunch of other stuff. You have a duty to notify escrow if you're assigning anything. They've added language that allows, I'm just going to run through these and we just go to the next group. They've added language about how the buyer is to choose their warranty company. They've added language regarding what happens if the buyer does not provide the required deposit in a timely manner. They've added the window coverings. They've added the fact that a seller is now required to delist their smart devices from all the accounts. New language regarding the NHD and some other government reports. And so again, what I'll probably do, we're getting ready. We just did a newsletter that's going to be coming out probably on Monday. The next newsletter, I'm going to go over the RPA and some other stuff that's coming down the road. So let's go to the next, and then they've changed some signature lines. So they made quite a few little cleanup, nothing massive other than the 3G3. I think that's probably the most important because it does affect the seller, and does the seller want to pay those costs or not? The way I've heard it explained, and I really like this, is look, the seller agreeing to pay some of buyer's broker costs is no different than the seller willing to agree to make repairs or pay some closing costs. It's just, are you willing? And you can always talk to the seller about how much are you willing to leave back on the table and under what circumstances. And now this is something, if it comes up, that you can talk to your seller about. Next slide, please. So a couple of other new forms, just going to run through them really quickly because we did a newsletter. There is a rental property owner disclosure form. The current form, the one that came out in December, is, if you look at it, is a really good form for the owner of, and they're now no longer called landlords, they are rental property owners. The rental property owner will make certain disclosures to their property manager so that the property manager is fully aware of a bunch of stuff. It's very similar in a lot of ways to a seller property questionnaire, but for the broker. In June, they're going to split this so that you can now provide it to the prospective tenant as well and get a signature from the prospective tenant. So the tenant cannot claim, I didn't know, because you're holding it. Right now, what you would do is provide it to the tenant and get them to sign it or acknowledge receipt, but it's not part of the form, okay? So, and again, going through the slide, it's a 4-page form. So let's just blast through it. I'm not going to go through it in any great detail, but it covers parking, it covers meth, it covers non-statutory disclosures, it covers the pool, it covers a lot of stuff, right? And again, some of the stuff is going to be not applicable, right? And so you just leave it blank or whatever you want to do. Gas meters and all that. Next slide. Actually, go 2 more slides down. One more. And as you can see, there's a place for the property owner to sign and for the broker to acknowledge receipt. There is no place for the tenant. That changes in June with the new forms. Okay, next slide, please. A form that may be a day late or $1 short, as they say. This is the non-contingent offer advisory, which was plentiful back in the day of your super duper hot market, is no longer necessarily that relevant, but at least now we have an advisory. if in fact you're going to make offers without contingency, which I imagine are back in vogue again. Contingencies that I mean, and this is simply an advisory to the buyer that if you're going to make a non-contingent offer, I want you to be aware of this. They've had the quick guide. So what they really did is they just put the quick guide into a document that is part of your package. Next slide, please. Is it a good idea to have current property owner sign new documents and send to current tenant? You could, but they may not be willing to. Now, this is a really good new form, only to be used if there's solar. Don't make yourself look stupid by providing this form when there's no solar. Now, you already know that there's no solar. It's been disclosed, right? So page 1 is an advisory. It's meant to be read by the seller. It is meant to tell the seller, about ownership versus lease, about certain types of advertising material, about other issues relating to what the seller needs to know in order to disclose properly, as the contract requires within that first 7 days after acceptance, what is going on with solar. And then if you go to page 2, which is the next slide, it is also a questionnaire. And this is what you would have your seller fill out. Now, I don't know how you guys do it, the Barbaras and the Lisas and some of you others, Debbie and Joe and more experienced. I don't know who's else, because I only see the people that are on camera. The rest of you don't exist. I'm kidding, by the way. You exist in another world. I would have I would give this to my seller as early in the game as possible. Have them fill it out. I know you're here, Mass. I'm kidding. All Italians, we stick together. I would have the seller fill this out soon after, when they fill out the TDS and the SPQ. But like the TDS and the SPQ, I would not have them sign or date it yet, because that gives you the ability to go back and say, have there been any changes? Right? And so your call, that's not the law. I just don't like, and again, now I'm being told that properties may sit on the market a little bit longer now. And if you're one of those people that has the TDS, the SPQ, you do your Avid, all these things get done early on, which is a good idea, right? Because you're only going to have 7 days after acceptance to get this stuff over. But don't date it or sign it until it's ready to be shipped, because that allows you to ask the magic question. Is everything still current? Have there been any changes? Do you have a problem with plumbing? Has the solar changed at all? Just a tip, my personal belief that it's a good idea, but you don't have to do it. Keep my card handy if you don't, because you may get sued and I want the business. Next slide, please. So there's some other revised forms, and I believe if she told me she was going to try and do it, everything is redlined. So let's go and see if she did it. Let's look. Next slide. Yeah, yay. Okay, so I'm going to get mine because I still can't read this thing. In all of the offers and counteroffer forms, they've made some changes, and I want to dig it out here. Give me a second because I got so many forms here. Apologize, I hurt my hand, and every time I do certain things, it hurts like heck. They made the same change, by the way, on all of the forms regarding offers and counter offers, and that is that here's the deal. I go to Vanessa, she makes an offer on my behalf, and I tell Vanessa, I know appraisals are a little bit sticky right now because appraisers might appraise a little below, what I think I'm willing to pay. So I'm willing to pay $25,000 over the appraised value. Right? Again, as you know, the standard without anything else, it defaults to the property has to appraise at least the purchase price. But I'm willing to go 25 grand. But then Lisa has the listing and her client counters back. What all the forms now say essentially is that gap will remain consistent. In other words, let's say, Lisa, we make an offer at $800,000 and I'm willing to pay $25,000 over the appraised amount. And Lisa counters back at $825,000, right? It's still going to stay the same. All those gaps will be the same, regardless of, so there'll be automatic adjustments. And that's what the forms say, so that the difference between the offered price and the appraised contingency will remain the same, even if the purchase price changes. Okay, so let's move on to the next slide, please. Cancellation of contract. They've made a change that says that if there's no timely that's a proposed mutual cancellation, but it has to be responded to within a specific period of time. So you can take a look at this. And again, I think Adam said that they're sending out this PowerPoint, so you can see what it looks like. And my understanding is all the forms are still online as redlined as well. So you can take a look at yourself. Next slide, please. Next slide. One more. So they made a change in the name. Still the same call number. It's still the ETA, but it's no longer called the extension of time addendum. We've done away with Latin. It is now the extension of time amendment. Okay. And they've also made a change again where you send a request to extend time. And again, to keep things clear, just like in the purchase agreement, there is an expiration, and that is now new paragraph 5. Okay, so they cleaned that up just a little bit, and that's now your new form. Okay, so if you see, don't be looking for the extension of time addendum. It is now the extension of time amendment. Next slide, please. All right, and I'm not going to go through. They made a whole bunch of little changes. So for property managers, maybe have Mr. Rodriguez call me, and I'll kind of go over all that stuff with him, because but they've changed the residential lease after sale. Remember, this is the form that you would use if the seller is going to remain in the property for 30 days or more, right? If they're going to stay for anywhere between 1 and 29 days, you use the SIP, which is the seller in possession form. And I don't believe they modified that in any way. Okay, so let's move through this and I'll show you the highlighted changes. Next slide, please. Next one. One more. We're getting there. I think it's on page 4. Nope. I guess it's page 5. But there's a paragraph that they made some. So keep going, keep going. It's an 8-page document, so unfortunately, we've got to run through it. One more. All right. This one was not done in red line, so I apologize, but I'll look it up while I'm talking about some other stuff. The question came up: Can you offer free rent? What you could do is make them pay rent or hold some money back in escrow and agree that if they leave by a certain date and the property doesn't have any damages, all the things that you would agree to, then they get the money. So yeah, there's lots of ways you can protect your client by leaving money on the table. I'm negotiating it's my case from hell. It's an unimproved property. And it is my personal case from hell. And we're leaving about $500,000 on the table because of some title issues that we have to clear up post-close. So you can do all sorts of things if it's properly negotiated and properly documented. And if the thing is, let's say Barbara is protecting her seller and she wants to make sure that we're out on time, put some money on the table and say that the rent becomes free when and only when you move out. Otherwise, it becomes money that belongs to the seller. And again, talk to your lawyer, make sure that there's not any side issues, because again, I'm not here giving legal advice. The bed bug disclosure has been modified. And remember, the bed bug There's a lawyer up in Encino. I don't remember his name. He's won 3 or 4 multi-million-dollar verdicts against landlords for bed bug infestation, usually involving kids. And those of you that are moms who would sit on a jury with a kid who's been brutalized by bed bugs can imagine how much money you would award to that kid and his family if the tenant or if the landlord knowingly rented property without proper disclosure, proper cleanliness, and all of that. Okay, so the bed bug disclosure was cleaned up a little bit. Next slide, please. Oh, I also want to remind you guys that the RLAS, all these forms are included with the RLAS. So there's a bundling that goes on: tenant flood, bed bug, all the mandatory things that you're required to give. Next slide, please. We're going to blast through this. I'm going to, but because you get these, most of you know this already, the rent cap and just cause addendum form. Next slide, please. Keep going. I'll tell you when to stop. Just keep pressing that magic button. Okay, there are all some stuff now that go with all the leases, have to do with, mold infestation and some other things too. All that's included now with the RLAS. Okay, so if you've got a residential lease after sale because somebody's staying for more than 30 days, you have a landlord-tenant relationship, and that's a different legal relationship than a license to stay for 3 or 4 days, right? I have some friends coming in from California. You people come in like every month, right? And that's a license. I'm allowing them to use my guest room, right? By the way, anybody that hasn't seen him in a while, I had dinner with Gino on Monday night. He looks great. His wife Lisa looks great. They're having a ball. They did the whiskey trail, which is something that's very religious here in Tennessee. And they had a ball. I had dinner with him Monday night. It was just great to see him again. Anyway, moving on. Next slide, please. And by the way, the whiskey trail is really cool for those of you that like whiskey. Keep going, keep going. I want to get to the next slide, the next form. One more. Again, these are all included for you. And we have a move in and a move out inspection. Again, very much like the SBQ, goes through. Again, this is more for people like Debbie that are, that do landlord tenant work. And then there's a separate, but virtually, I won't say identical, but virtually identical move out inspection. And these were all revised in December, brought up to date, cleaned up. And I really like these forms because now you're doing this with the prospective tenant, right? And so you have a record of what the property looked like, and taking pictures of anything that might be a question. So let's just blast through this. But there's a move in and a move out inspection. I'm just going to check something real quick. So keep going. And as you can see, there's a lot of yes no's. Now, you guys aren't probably going to do this because most of you are residential, but for those of you that occasionally do a rental, or for those of you that are actually into property management, this is a critical form. Let's go to the move out inspection, which is the next form, please. And as you can see, it's virtually identical, right? So again, let's blast forward. We're getting to the end, which is a big yay, I guess. A lot of stuff. You guys had 40 forms come out in December. So just be aware you had a ton of new forms and a ton of revised forms. Keep going, please. Again, the seller counter offer, the only thing that really changed was the gap issue. So you now, and that's true of the seller counter and the seller multiple counter, which you may still get a few of those. Again, the market hasn't gone totally south. So let's keep going. Next slide, please. So they just made that one change, and they made it, again, same exact change in the seller multiple counter, where they're using the gap to clarify, because that was becoming an issue when they originally came out with the form. Well, does that mean that I'm now paying $25,000 plus whatever Lisa countered at? So now I'm willing to pay $50,000, and there was some controversy around the state about that. That's why they cleaned this up. Next slide, please. Next. And then they've made a lot of, I'm not going to go into this. I'll be happy to talk to the property management people, but they made a lot of changes to the property management agreement, right? And I don't know if it's feasible, but you may want to consider asking your clients to re-execute. Take a look at the changes they made, and then consider asking your landlords if they'd be willing to re-execute this agreement, because it really is a much better document than it was. And I just finished working with the Department of Real Estate on a property management question. They're really clamping down. They're doing a lot of audits right now, as some of you unfortunately know. And so you really want to have your property management file documented as well as possible. Understand that NAR did a study, and they do it every year, and I just got it. Dual agency is the #1 way you are going to get sued. Property management is #2, right? And when I say sue, have a legal problem, could be the DRE, could be fair housing. So just be careful. Let's move on through this property management agreement. But again, there's just a ton of changes in it, and I don't want to take the time. If I finish early, I can go back. But again, they, as you can tell, they call it a revision, but it's almost a complete rewrite. When you look at all the red, Dan, you got it. Thank you. All right, next slide, please. One more. One more. We're getting near the end of the revisions. One more. Dan, you got it. Thank you. Don't touch that button again. All right. So a couple of other revised forms. You have a privacy form. It's bundled with a lot of other stuff. They've really, basically, when they wrote it originally, it's because a new law was going into effect that was terribly written by the legislature, which is unfortunately not necessarily, as Adam knows, not necessarily an exception any longer. But now that CAR attorneys understand it, got a better feel for it, they've turned it into a 3/4 of a page advisory. And so that's what you have now. It's bundled, like I said, with a lot of stuff. They've changed the manufactured mobile home purchase addendum and the transfer disclosure addendum. So I don't do mobile homes, and so I don't feel qualified to even go over these with you, but they're there for those of you that do mobile home transactions. Next slide, please. The lease listing form has been modified. The pre-move out inspection statement been modified. The notice of right to inspection prior to termination of tenancy form was revised, and the application to lease or rent. Now that is an important form. I'm actually sorry I didn't put it up. There's a new law I'll talk about later regarding screening and using the same screening report multiple times over a 30-day period. And this form now also reflects that you can do that. So they did make some pretty good changes. And again, it's more for the property managers, but there is now a really good, clear and up-to-date and legally legally integrated with the new law regarding that form. Next, then they've discontinued forms, but as you can see, mostly regarding coronavirus. And as long as you guys stay in Southwest Riverside County and have Adam as your GAD, you're in good shape. But I got to tell you, you don't want to do, if you do any kind of sales in Santa Monica or San Francisco or any place like that, I will pray for you. Send me an email and I will pray for you on Sunday. Next slide, please. All right, so what's going on in June? I'm not just going to give you a real quick preview, sort of like going to the movies. We're going to just do a real quick preview. I'm not going to put these forms up because they are all in draft. When we all go to Sacramento in May, they'll be discussed. There may even be a few additional forms, but there's going to be one, as of now, one new form. And that is a form, let's say you have a situation. Susan, hi, Susan Johnson, nice to see you again. Let's say you have a mixed use transaction, and part of the transaction includes 4 or less residential units along with retail or commercial. Okay? There's a case that says that you have to do a transfer disclosure statement if there are less than 4 residential units. What happened in that case, the buyer failed to perform for almost a year. They didn't even use the SRCAR forms. They used the commercial forms. They had this. Nobody thought this was a residential transaction, but there happened to be 3 residential units on the property. Long story short, the buyer doesn't perform. The seller sues for breach of contract, and the buyer had a better lawyer. They argued, well, wait a minute, we never got a transfer disclosure statement. And the court said what the statute says, it is not waivable, and therefore the buyer retained the right to cancel until they got a TDS, which of course they never got. So having that in mind, there is now a residential, there will be in June, a residential units purchase addendum. So if you're working on a transaction where there is basically mixed use, and we'll go over this form at the next brown bag once it's finalized. Obviously, right now, this is just a 2-page draft, but this is the form that you would use as an addendum because, again, you have mixed use. And so you're going to want to carve out the residential and do your TDS or TDSs on those, along with avids and all that other stuff, because there's a different set of laws than there would be for commercial property. You guys all understand that? This form comes out in June. Now let's talk about what's being revised. Somebody mentioned before the the real estate transfer disclosure, the TDS form. This is a mandatory form unless that's specifically exempt. What they're changing, one little change at the top of the very first page above everything. This property is a duplex, triplex, or fourplex. This TDS form is for unit number blank. Additional TDS forms are required for the other units. So if I'm selling, let's say Brett is selling a triplex, okay? You need 3 TDSs. So you will now, at the very top, fill in, this is for unit 1, 2, or 3, or A, B, or C, whatever number it is. And now you do the TDS for that unit. And then you do pretty much a repetitive of all 3 of the units. And I believe, yes, Debbie, it would include ADUs because that is a separate property, right? I just think, here's my deal. You're never going to get sued for being wrong about doing too much, right? You are going to get sued, on the other hand, for not doing it correctly. The poor seller in the, I believe this case was called Hartman, but don't quote me on that. But in that case, the seller, I mean, he did everything right. The seller was the good guy. And he got not a dime and had to pay the buyer's attorney's fees simply because nobody thought to use a TDS, right? Again, it just happens that way. They're also revising the team agreement. We have a $400,000 team dispute right now because teams are people. People get into disputes. If I'm a broker and I have teams underneath me, I am mandating that they use some form of an agreement that I can now have in my file that I approve that deals with termination, removal, the right to hire employees, and then what happens to commissions if I leave. And we have a case where there's a team member, the agreement was all verbal, handshake, that we split things in a particular way. He then left and went to another real estate office. There were about close to $400,000 worth of commissions that were earned after he left on properties that were moving along before he left. And now they're in a big dispute. It's already gone up to the Court of Appeals. It's coming back. It's going to the board for arbitration, not your board, but another board for arbitration over the dispute. And the poor broker's sucked in. Why? Because 2 of his agents are having at it. And the commissions are all earned by the broker, right? So the SRCAR has a real good team agreement. and they're going to make a couple of revisions to it in June. Again, I would have you take a good close look at it, and make sure that you understand what the team agreement is, what the changes were, because come June, there's going to be a change to the section on future transactions with pre-existing clients, which I imagine would come up in a team dispute. The revised exempt seller disclosure, which is a form when the property is exempt, there's still disclosures that have to be made. And so they've made the same change that they made to the TDS, which is that if it's a duplex, triplex, or fourplex you identify. They've made a couple of changes to the seller property questionnaire. Again, the same basic change regarding duplexes and all of that. They're also going to make a small change to the section on title and ownership. I'll go over that with you before it actually becomes final. A form that I wish, if I were live right now, I'd be asking for a show of hands. How many of you use the statewide buyer and seller advisory? One of my favorite forms, right? It is a great risk management tool. It is long. It has been recently reconstituted so it flows better. And they're going to add 2 paragraphs in June. One paragraph, thank you, Dale, appreciate it. Probably will never hear from you again because you're not going to get sued, because this is a really great risk management tool. Here's the deal. We all know preliminary title reports are important, and what they're doing in the new form is emphasizing how important it is to go over preliminary title reports, review them, and all of that. Okay, and then they're making a change. I guess in California, you guys are doing electrification. I guess gas is bad, and so there's going to be a paragraph on electrification. I can look my nose down because I don't live there anymore, but I still work there and I still grieve for all of you. There's going to be a change to the rental property owner questionnaire. I've already told you about that. That's where there'll be a couple of minor changes, and then the whole back page will be modified a little bit, the mold and the asbestos, and then there'll be a place for the tenant to initial that they've received it. They're going to make some changes to the probate agreement. Here's a good one. Debbie, pay attention. Where are you? There you are. Pay attention. There is a change to the animal terms and condition addendum. It's really almost a new form. Okay. And it talks about, remember, for those of you that aren't aware, don't do a lot of property management. The Department of Fair Housing in California has ruled that service and companion animals are not pets. Therefore, if you have a no pet policy, it does not apply. Okay, so it's important if you do have a no pet issue, you have this form filled out. And again, I don't know what the final version of it's going to look like in June, but that's going to happen. They're modifying the assignment of agreement addendum, where the buyer is assigning some or all of their rights. There's going to be a place for you to initial that. And then there's the additional broker acknowledgement. Again, some minor changes to that form. So those are the forms that'll be revised in June. So get ready, here they come. And again, we'll know in May whether there are going to be other forms besides that. And so, keep your eyes peeled. Film at 11. Some new laws just to keep you up to date. In January, and Connie has it, there is a 3-page summary of what we thought were some of the significant changes. We're doing it a little differently now. I felt bad that the guy that actually writes these doesn't get credit. So, because frankly, all I do is go through it, edit it, make the changes. So you're going to see a guy named Bradley Greenman. I didn't even know his last name was Greenman up until this very moment. But Brad writes these newsletters based upon what I've asked him to write about. And then he sends them to me and I go through them. And so up until now, I've been taking full credit, but that's dishonest. So Brad's name is now on this, but he wrote some new laws. And so let's go over a few of them. They made some changes to the licensing laws. If you're going to go get a broker's license, there's a certain level of experience you need, and it has to be current. It's not like I had experience 20 years ago. Now I'm coming back into the market, right? You've got to have current experience. Unless you're a lawyer, I can sit for the broker exam anytime I want, right? The HOA cannot restrict you from commenting about the HOA in social media. Okay. And there's also limitations on long-term rentals. They can pretty much do whatever they want, subject to the governing documents on Airbnb type short-term rentals, but they cannot restrict long-term rentals except under very narrow circumstances. What the banks were doing, and somebody mentioned more inventory a little while ago, what the banks are doing is they would get a lot of foreclosures and then they would bundle them, and some big investment hedge fund would buy them, and then they would sell them however they wanted. That's been tremendously limited in California now. And I think that's actually a good thing, because that'll help with inventory if we start seeing a lot of foreclosures, and there are some people that are thinking we might. Next slide, please. Remember I told you before, there's that form for tenant screening. Basically, if I'm a tenant, I'm looking around, I'm paying a screening fee here, and then I'm paying a screening fee over there. Now they have, subject to the landlord's willingness to use them, and under the circumstances of the statute and of the form, reusable tenant screening. So I can pay for a screening fee, get a screening get a screening report, and it's going to be good for, I think it's 30 days. Whoever's not muted, please do so. Thank you. There's also a tenant domestic violence protection law. And this is a situation where, let's say it's a woman and her roommate, she signed on the lease, her roommate's on the lease, and he is abusive, right? He beats her, or whatever it might be. Or another tenant in the building is committing domestic violence. The law says that she can get out of that lease without any penalty whatsoever, right? She has to show certain things. She has to establish she's asked for an injunction, all of the rest of that. They've cleaned that law up a little bit, and so they revised it. It's in the newsletter. If I have been foreclosed on and the foreclosure has been completed under the new law, under certain defined circumstances, this is where the lawyers will have to come in and look. Let's say, for example, Lisa, you go to the auction, you bid, you get the property. The person who has been sold out under certain circumstances is allowed to say, hey, bank, you sold the property to Lisa for $50,000 less than I owed on it, right? I have the right to then match that number. And again, it's to try and keep people in their house. How it's going to work, I don't know. We'll see. The Judiciary Omnibus Bill, I can never remember what that's for. Oh, this is a good one. Yay to Sanjay and the rest. And it doesn't happen very often, I'm guessing, but sometimes the law changes relative to disclosure while I'm in escrow. Right? Now the question is, do I got to go back and amend everything? This bill says no. Whatever the law was on the day of the transaction, that is the law for that transaction. Okay? That doesn't mean you shouldn't, if you know, but again, it doesn't happen all that often. But if it does happen, that's going to be the deal. Next slide, please. Again, there's limitations if you're appointed a conservator on the sale of the residence of a conservatee. I guess is the term. So be aware of that. Professions and vocations, 1495. My recollection is that's the one that says that you now have to take implied bias classes. Now be careful. I had a case the other day where a company was advertising that they were offering the class. Two bad things were occurring. Number one, the class wasn't being offered for credit. Well, what good does it do to take a class that you need credit for if you can't get credit, right? Susan, you take a broker supervision class, you have to take a test, and then you pass it, you get the 3 or 4 hours, whatever the class offers. It's the same with an implied bias class if you take the right class. And then the other thing is it was clearly being used for nothing more than recruitment of other agents. So bottom line, you're going to have to take the class whenever you're ready to renew. If you're moving into, the new people, they're not quite ready yet. And so that statute will not go into effect until January 1st, 2024. But for most of you, check with the DRE, you're going to have to take an implied bias class. And it has to be done for the appropriate credit, just like all your other DRE classes. And so that's that. Next slide, please. Uh-oh, got a typo. And again, the implied bias, I got to tell you, and I don't mean to sound preachy, and I'm pretty conservative. Most of you have probably gathered that. I mean, I left my home state to get away in part from the politics of California. But there's a point at which you have to say what's right is right. And what's right is that if I can afford to buy a certain piece of property, I ought to be able to buy that property. And clearly, blatant racism, blatant homophobia, whatever you want to call it, whatever these new cliche terms are, sometimes it's very real. But most of the time, it's implied. There is, right? Well, you'd be more happy in that area, right? Why? Because that area happens to be mostly Hispanic or gay or Black, right? Or you really don't want to live in that area, a lot of old people, because your children are going to annoy them, but it's not a senior development. And it's important that we understand what biases we have, and that's what the purpose of the class is. Now, Adam, jump in if you feel like it, but there's some really fun stuff on the horizon in California, right? A lot of counties and cities are talking about, if you have a property that is vacant for a period of time, we're going to call it vacant land and we're going to tax it. Or we're going to tax property that transfers higher, and we just need the money. And the fact that it affects housing is too bad, but we really want a lot of housing. There was a bill that Adam and his peeps beat back, but a lot of people are saying it'll come back again because the assembly people from San Francisco are very powerful. And in San Francisco, there's a rule. It's also existing in, I believe, Santa Monica, where if I want to sell my rental property, I have to. Sounds like somebody was not happy. I have to offer it first to my tenant. And if my tenant can't buy it after a certain period of time and under certain circumstances, I have to offer it to one of these nonprofit groups that allegedly buys property and provides affordable housing. It really delays the process, as you can imagine. Oh, and then if I sell it for less than what that original right of first refusal was, it really becomes a right of last refusal. And the estimates are that it could take, a year to get this thing through the entire process and delay the sale for that extra period of time. And then this is one I really like. Right? The landlord is responsible for preventing domestic violence, for making sure that kids don't get kidnapped and beaten up, and all these things and some cities have passed crime-free zone rental ordinances. I don't know if there's any in Southwest, but they've done that. And that's what they've done, because you know what? As a person who lives in an area with a high crime rate, right? I deserve to not have to worry every time my children go to the store that they're going to have a problem with another tenant, et cetera, et cetera. Now they've adopted, or they're introduced a bill, I think it's 1418 Assembly Bill, something like that, 1415, that says basically that a city can't adopt certain crime-free zone bills to protect the prospective tenant who might be a convicted criminal. Right? The schizophrenia of the California legislature is fun to watch, right? You guys had 997 new laws go into effect on January the 1st. In Tennessee, we didn't have 900 bills introduced the entire year, but probably half of that, not even half of that. So let's go to the next slide, professional standards. And this is important. I want you guys to listen to this. We're getting toward the end, and it's 1 o'clock your time, right? So I think we're supposed to go to 1:30. Is that right, or 2? I don't remember. Doesn't matter. I'm going to keep talking. You can go. So here's the deal. Lisa and Barbara get into a hissy fit over who's entitled to the compensation for the successful closing of 1234 Maple Street, right? And the
How dare you, Lisa? Can't believe it.
All right, that was probably Barbara. And I love Barbara, but she's annoying. Don't you, everybody agree Barbara can be annoying? I'm kidding. So Lisa, you two get into it.
You better be kidding, John. I swear to God, I know where you live.
I love you to death. And I know where you live. I've stayed there. All right, here's the deal. Lisa showed the property, worked with the clients, and then they left and they went to Barbara. Now, Barbara may or may not be the listing agent, right? And so the hearing officers are, Lisa thinks she's entitled to 25 grand commission. Barbara says, no, you're not. I'm entitled to the $25,000 buyer side commission. And that's what the fight is always about. It is always about the buyer side commission, which means that there was a successful closing under almost all circumstances. The rules are in the MLS, which means it doesn't have to be a realtor. If Barbara was not a realtor, it wouldn't matter if it's a dispute over commission. So how's it work? Well, Lisa files her complaint. Barbara's notified. Barbara files her response. It's set for a hearing, and there will be 3 panel members and an alternate, and they will make, for the most part, the final decision. And assuming they do a good, fair job, they don't have to be right because we all make mistakes, but they have to give it a good, fair, unbiased hearing. And if they do that and follow all the due process rules, then the winner gets to keep the money. It is a mandatory binding arbitration. There is no appeal except for violations of due process. So how does the panel come up with that decision, right? Apparently Lisa's just been offered the commission by text because she's happy. So what the panel is going to be given, besides the complaint and the response and any related documents that either side files, is they're going to be given
to his coronation on May 6th.
Ellen,
Insiders speculate
Ellen.
that they should take the opportunity.
Thank you. So they're going to be given what we call the factors analysis. And it's 23 different factors that they can consider, all or parts. Some are relevant, some won't be. And they'll go through these. It's not a scorecard. Lisa could have 12 of the 23, and Barbara only has 3, but 3 that Barbara has pushes over. It's called preponderance. And what that means, if any of you have ever played with a teeter-totter, right? You start putting one block on one side, one block on the other, but eventually there's enough blocks called evidence on one side to change the scenario. And only when the blocks are completely even will they split the commission in half. Otherwise, Barbara's going to get all of it or Lisa's going to get all of it, okay? And so, again, they've made some changes to it effective December the 19th for transactions that occur or hearings that occur after that date. Number one, they've been told, they being the hearing officers, to give the existence of a buyer representation broker compensation agreement great weight. Does that mean that if Lisa has a BRBC and Barbara does not, she's going to win? No. But if she has one and everything else is equal, that's a pretty good little peg on her side to hit the issue of procuring cause and preponderance of the evidence. So there will be a great emphasis on, particularly if Lisa don't change, go back, please go back. There'll be if Lisa has an exclusive or a non-exclusive, that will be critically important. And I did all the hearing officers a couple of weeks ago. Some of you were there. And you remember that one of the issues is it is now considered mandatory. It is part of your standard of practice that you will ask. Barbara will ask, have you been working with anyone else? Why, no. Okay. And unless there's some other way for Barbara to check that, maybe that's going to be enough. But every case is going to be different. That doesn't necessarily mean Barbara's going to win. That simply means now we go back to the balancing act. But if I say yes, I have been working with another agent, I might even be dissatisfied with her. Lisa doesn't return phone calls. I sent her a text at 3 a.m. It took her to 4:30 to respond. That kind of stuff. So the bottom line here is you got to ask. You got to ask. And then if I say yes, now Barbara has to ask what? What kind of agreement, if any, did you sign with Lisa? I don't remember. I remember signing something. Now it is incumbent upon Barbara to do what? To find out, maybe call Lisa, maybe ask for a copy of the document, whatever it takes for her to get a copy of that document. Was the property that closed and for which the commission has been earned, was it described in the document that Lisa provided? The broker involved one of the documents. And again, great weight, and it's going to be greater weight, obviously, if in fact it's exclusive. But if it's non-exclusive, Barbara still needs to figure out what Lisa did, because again, Lisa brings a claim and she's established to the satisfaction of the panel that she really was. Remember, it isn't about who closed the deal. It's about who procured the buyer. You guys got to understand that distinction. And so if Lisa procured the buyer, Barbara's going to do a lot of work. Barbara's going to incur a lot of liability. Barbara's not going to receive a penny of compensation. Okay. So was there a written agreement? If so, what was it? If it was exclusive, was it canceled? If it was non-exclusive, was it canceled? Has there been some arrangement to cover Lisa if in fact there was? Because again, under the code of ethics, Barbara has an affirmative obligation to try and prevent me from having to pay 2 commissions. And remember, even if Lisa doesn't win on a procuring cause claim, she could prevail on a breach of contract claim against me individually, right? I might have breached my contract with Lisa, even if I'm not the procuring cause. Probably not, but we're waiting to see. This is going to be a much more interesting class next year, right? When we have a little bit of experience with what's going on. Again, there are contractual rights that Lisa has by virtue of a signed document. And again, there's now great emphasis on asking and were you involved, right? Because if Lisa didn't show the property that Barbara ended up selling, no harm, no foul, tough noogies for you, unless it's exclusive. And then again, in showing, were you, and the phrase that they're using, and again, this means nothing to me, but were you significantly involved in procuring the buyer? Right? That's the $1 million question. So again, for a lot of you that train, I know Barbara, you do a lot of training. I noticed that Susan, you have a class coming up. These things need to be emphasized, right? Because you don't want to walk away from a situation like that poor gal did with a $920-something thousand commission, and she got zero. Well, she got the listing side because she was the listing agent, but she got zero for incurring all the liability she incurred with the buyer as a dual agent. Don't do that. Don't do that. And there's a lot of other procuring cause issues, and I don't have time today. I'm going to send a class over to Connie that I'm just about done with. I've done it once, making a couple of changes to the, and it is the buyer representation class. It's 4 hours, and we do a deep dive into fiduciary duty. I don't know if anybody wants to take it, but I'm going to offer it. We'll see. I'm probably going to do it with a broker. I've got one in mind. I've already talked to her amongst you guys. So we'll see how it works out. Next slide, please. Let's move on, because I know you guys, it's not Friday, is it? It's Thursday. That sucks. I wish it was Friday. So many of you have big mouths and you talk bad about other people. Nobody that I can see, so all these people that are off camera, they're probably talking about other people, right? And that's a violation of the code of ethics. If I knowingly make a false statement about any other real estate professional, I could be brought up on charges under the code of ethics and be fined up to $15,000. I could also be sued for defamation of character, et cetera, et cetera. But up until January 1st, we didn't know what is a real estate professional. We now have a definition. A real estate professional, which is described also in Article 11, is a real estate professional who engages in real estate, residential brokerage, real property management, commercial and industrial real estate brokerage, land, real estate appraisal, real estate counseling. Next slide, please. Syndication, auctions, and international. Okay, just to be clear. So if I, and I've already had a couple of issues at another board where they were bad-mouthing the appraiser. Now, I've seen a lot of appraisers that deserve to be bad-mouthed. The question is it knowingly false, right? And if so, that appraiser could file a claim against you under the code of ethics. Yes, they should add lenders, but if that were the case, I'd be brought up on charges because lenders tick me off all the time. Probably you guys too. So that's the deal now. Don't disparage people. And again, disparagement is making false knowing claims about somebody's character and or their performance of their jobs and so forth. Made a couple of changes to the code of ethics, very minor. Under Article 1, I think it's standard practice 1-16, it spells out how a listing agent is supposed to provide access to the property. And it says essentially, in accordance with the instruction of the seller or the owner, right? So ethically speaking, part of my obligation, I am to work out something with the owner and find out how they want access to be provided, you know, open house, lockbox, appointment only, whatever you guys do, right? And I put that in the MLS. 3-9 then is the buyer's response, right? If I'm Susan and I'm showing a property that Janice has listed and it says in there how that's to be restricted, which was a really big deal during the pandemic, then Susan is obligated to limit access in that manner, unless it's blatantly unlawful or discriminatory, which is rare. So they changed the language of 3-9, Article 3, Standard Practice 3-9, to say exactly the same thing, in accordance with the instruction of the seller or the owner. Okay, so that change has taken place. And then in Article 10, which is the discrimination article, they changed the word handicap to disability, right? Because it's a broader term, frankly. And under the Code of Ethics, you have 9 standards of practice, or 9 protected classes: race, disability, familial status. But you guys are big winners. In California, you have 22 protected classes. Okay, so be careful. Next slide, please. MLS, real quick overview. We're going to do a legal panel. I got to talk to Connie. It's going to be my recommendation that we ask Ed Zorn to participate because there's so much going on at the MLS. She'll make the call, but Connie's pretty good at listening to what I have to say. And so I just want to give you some brief rundown. Why is all this happening? Why are we doing so much with the MLS? Number one is there's a bunch of class action lawsuits that are pending against NAR based on how NAR requires compensation in the MLS. And there's 3 lawsuits, and the total amount of damages that are estimated to be included in these 3 lawsuits is between $4 and $8 billion. So these are really serious issues, right? Basically, they have to do with, I'm listing my property for sale with Susan. Susan has agreed to charge X%, and she is mandated to then put it in the MLS unless I've instructed her not to. And she will offer a percentage of her percentage, could be 50% or whatever it is. According to Zorn, the vast majority of listings that go in the MLS are at close to 50% of whatever the list price is. Very few are in the $1 or 500 and less. It's mostly, pretty reasonable because, again, it's an ethical issue. So she puts in there half of whatever she's earning. What just really happened there, according to the plaintiffs? I, as the seller, am paying Bill Tyler 50%, or I'm paying his commission to negotiate against me. And it's coming out of my proceeds of the value of my house. That's the argument. You don't have to agree with it, and obviously, when there's billions of dollars at stake, it's a lot more complicated. And then there's also a buyer's case that's pending, which says exactly the opposite, that Bill's buyer client is being forced to pay Susan's list side through the purchase price because the commission that's being earned is being added onto what Bill's client has to pay. So those lawsuits are pending. Federal Trade Commission is looking into the unfair business practices of organized real estate. President Biden issued an executive order. And again, I could spend a lot of time talking about it, but one of his people worked for a think tank that thinks that your methods of compensation are grossly unfair to consumers. And so they're looking at it. They could issue a new memo or a new regulation anytime. Department of Justice, potential compensation concepts are being considered, right? If in fact it's no longer going to be considered proper to mandate offers of compensation in the MLS, what's going to replace it? Right? There's got to be a plan B, probably a plan C, D, E, and F as well. So all that's being discussed. There's some experiments going on in various parts of the country dealing with how compensation is to be paid. For example, I'm a lawyer. I work for Bill's brother's law firm. I don't work for them. I'm of counsel to them, which is a fancy way of saying they've pretty much put me out to pasture. And so I work off of different business models. I charge a flat fee, or I charge a percentage of whatever I'm able to obtain for my client. Very rare in real estate, more so in the personal injury area. Or I charge an hourly rate. You guys pretty much charge what the personnel or the property, not property, the personal injury people charge. You charge a percentage, right? That's probably going to change, right? That you probably, if you look at the BRBC, you'll see that they've come up with a bunch of different ways of being paid that in anticipation of things that are going to happen down the road, right? The Department of Justice entered into an agreement with the NAR a couple of years ago that resulted in some rule changes at the MLS level, including all of this transparency of commission issues. And then the Department of Justice reneged, and NAR petitioned the court, and the court agreed with NAR and has ordered the Department of Justice to comply with the prior settlement. In the Northwest Seattle area, they have a broker-owned MLS, and so they're not required to follow NAR rules. And they've completely changed the way compensation is being offered. Started in October, and it's being tracked by everybody. And so far, so good. And the thrust of it is it becomes a negotiation most of the time between the seller and the buyer's broker, right? And they changed their RPA, they changed all of their addendums, and we're monitoring that, and we'll come back to your board of directors at some juncture with some recommendations. If Ed's invited to the panel, he can explain it better than I can because that's his world. And then I want to warn you guys, particularly the brokers, I have a list here of the top MLS rule violations, and one of the problems that's coming up is, let's say I'm a broker, okay? Joe, you're a broker, right? You got a lot of agents, over 100, right? So let's say that agent number 1 gets a citation and they don't take care of it. And then agent number 2 gets a citation and they don't take care of it. Agent number 3, same thing. Well, each agent has only got 1 citation in that year that they didn't take care of. But Joe's got 3 because they're his listings, right? And now there's a 4th citation that's issued. Now Joe gets to come to the association's grievance committee and explain why he has not violated the code of ethics. It will be set for a hearing, and now Joe's got real problems. And we're seeing a lot of those. If you notice that one of your agents has gotten a citation, deal with it. Because if it happens 4 times, you're exposed to $15,000 fine and other ethical issues. And if they decide that it's serious enough and you don't have a policy, it'll get reported to California Association of Realtors and get published on their website. So, word to the wise. Next slide, please. Liability. And we've talked a lot today about duty, right? One of the things that we're going to do whenever I share the broker classes, we're going to spend the first 15 minutes on dual agency and on fiduciary duty. But for right now, this liability means I have a legal obligation or duty. I breached it. I fell below the standard of care. That was the causal reason why my client then suffered damages. So duty, breach, causation, damages. Those are the 4 elements, and you guys call it liability, right? Right now in California, if it's a disability claim, the number 1 fair housing discrimination disability or discrimination claim is not race. By far, it is disability. And we're getting lots and lots of calls and concerns about website disability. There is a quick guide for those of you that have your own websites, or if you're a broker who has a duty to oversee the advertising of your agents. There is a quick guide that is available through SRCAR. It's a website. It talks about websites and how to make them compliant. The leading case is actually a Domino's pizza case, right? I'm blind. I can't order a pizza online unless certain software integration exists, and Domino's didn't have it. And they got sued and they lost, right? People would say, well, if you're blind, you know, how do you read a computer? You can. There's all kinds of ways of doing that now. And so most of you have websites. And so you got to be cautious about that. And the law is very, very liquid right now in the area of Americans with disability. Next slide, please. So if you get a letter about your website, or you get a letter about your, something to do with ADA, take it very seriously. A couple of real quick cases. We just did a newsletter on 3 of them. So I'll cover real quickly. In Syrian investment versus Farkendabler Poor, however you pronounce that name, the commissions that the investment company earned were under false pretenses, making false promises, claiming false things. I point that out because, again, it can be established that the commissions that you purportedly earned were made under false pretenses, there's a real possibility you might not get your commission. Now, for Debbie and the other property managers, you cannot evict except in accordance with local ordinances, so long as those ordinances have not been preempted by state ordinances. So at a minimum, you have to comply with the state ordinances about eviction, right? And if you don't, at the end of the day, all I have to prove is that you didn't comply, and I win even if I haven't paid the rent or done other things. There's a really interesting case called Cameron. Mrs. Cameron was being evicted, and she happened to be a senior citizen. So not only did she not have to be evicted because they didn't comply with the eviction ordinances, but she also was held to have an elder abuse claim. Okay, so that's those three cases. Now we finally have a good case. Let me talk about it real quick. You're going to get a newsletter next week. So let's go to the next slide, please. Whitlatch versus Premier Valley, which is a Century 21 franchise. There's been a long-standing argument in California. Are real estate agents employees or are they independent contractors? And Whitlatch filed a lawsuit against Premier. He tried to make it a class action that said that he was an employee of Century 21 Premier. And Premier said, no, he's an independent contractor. And the court held in our first actual written opinion in favor of Century 21. And we just wrote an article on it, kind of lay it all out. You still have to have workers' comp, but so long as number one, the agent is properly licensed. So can you turn over a bunch of stuff to a TC who's not licensed? If I lose my license, can I still work in the real estate field? No, I am going to be somebody's employee at that point, and you better do it right. Number two, there has to be a written agreement. Doesn't have to be the CAR, independent contractor form. It can be whatever your company uses, but it's got to be in writing, clearly spelling out the terms of the agreement. And then lastly, you have to be paid on what's called an output basis, which is a fancy word for commission. It doesn't have to be your entire income. It could be, but it has to be the predominant income. Okay. Redlining, not a good thing. City National Bank just learned that. The Department of Justice brought a claim against them for redlining in their lending policies, and they have been required to pay a $31 million penalty to the Department of Justice. Okay. As I mentioned, the court has enforced the Department of Justice case. And then I wanted to bring up an old case. It's 1991 case, it's 20 years old. But it comes up a lot. It's called Carradas versus Home Fed. Here is the facts. Mr. and Mrs. Owner called the bank, Home Fed, and said, we're having a tremendous subsidence issue. And we really need to renegotiate with you guys because we can't afford the mortgage and fix the property. Home Fed said no, property was foreclosed on, and now Home Fed owns it and they sell it to Mr. and Mrs. Carradas. Mr. and Mrs. Carradas sue for failing to disclose a material defect. Home Fed raises the question, well, we don't have to do a transfer disclosure statement. We're exempt as an REO a lender, right? We own the property by virtue of a foreclosure. That is an exempt transaction for the TDS. And the case was dismissed. It went up on appeal, and the Court of Appeals reversed. Court of Appeals agreed and said, yes, Home Fed does not have to do a TDS. That is absolutely true. They are exempt from liability. However, under the common law, we still have fraud. And if Mr. and Mrs. Karadas can establish a fraud claim, then they will prevail. And so they sent the case back to determine whether or not HomeFed knew of the material defect and failed to disclose it, and therefore committed either intentional or negligent fraud. Why is that important for you guys? Well, you're probably not going to have that situation. But some of you sell property on behalf of other exempt sellers, right? If my wife and I both died in a plane crash, our administrators are going to take over and they're exempt, right? But our administrators are people we're familiar with. They've been to our house. If there were something that was material that they knew about, they could be sued, not for the TDS, but for actual knowledge of a material fact. So be careful when you tell people, well, you're exempt, don't worry about it, you don't have to disclose anything. That's absolutely not true. I thought I'd raise that back up again because I had a case recently and it was like visiting an old friend. Okay, next slide. Now, what are some of the trends that we'll talk about the rest of this year? We're seeing a real significant uptick in unhappy buyers. Why is that? Well, because a lot of people, particularly those that came in just before the market started to shift downward, right? They bought at the top of the market, just like they did the last time. And all of a sudden, they're either not appreciating any equity, or actually they're losing money, or they've maybe even paid more than the appraised value. Or they didn't bother to go look at the property because it was such a heated market. You guys are familiar with, you know, our memories are fairly short, but you guys remember what it was like last year, right? At this time, it was nuts. People were calling me, John, I got 64 offers. What am I going to do? Take the best one, right? I mean, it was just crazy what was going on. So the thrust of it is now we're starting to see some buyers come back. And according to Otto Katrina, who is the president, last year's president of SRCAR, about 60% of buyers are unhappy. And about 64% of transactions that occurred over the hot period without contingency. So be aware, keep your files handy, make sure they're in good shape, because hopefully not, but we may see an uptick. We're already seeing 1 in 300 transactions in California now ends up in litigation. Okay, so the odds are not good. Number two, there's an attorney by the name of Steve Spile, one of the fine lawyers that I know. He's an insurance expert. And I was at a meeting with him and some other lawyers at SRCAR recently, and he made a statement that I'm finding to be true, that is very conceivable that E&O coverage in California will crater over the next couple of years. Most of you have seen an increase in your premiums, right? A lot of big offices, according to some of the people that were at that meeting, the attorneys for the big companies are saying, what we're doing is increasing our self-insurance deductibles, right? We can't afford the increase in premium. So in order to bring it down to a budgetary amount, we're self-insuring. Then we had a speaker come in at the recent SRCAR meeting talking about the do on sale, or excuse me, the do not call. It's becoming so be careful if you're doing robocalling. Sitting someone else's open house has become a significant question. If you're going to do it, I'm not going to take up time now, but if you're going to sit somebody, when I say somebody else's open house, another company's open house, maybe you're Joe's agent, but you're going to sit in an open house for Sue. When I got two different brokers, you know, the client is Joe's client, Sue's, but it's not Sue's client. What are the parameters of that? I talked to DRE and I wrote a paper. I'm glad to talk to you about it if that's an issue for you. Deposit disputes are still very high. Remember, a deposit dispute by its very nature is a legal argument. So don't stick your nose in it. We're seeing a couple of cases where, you know, when properties were, when properties were flying off the market and you entered into a contingency for the sale of the buyer's property, no problem, because that property was going to fly off the market. properties are sitting longer now. So we're seeing some issues where the fact that the buyer can't sell their property is impacting the present transaction. So just be a little more cautious about that. I had a couple of DRE issues lately. Be careful about taking a gift card or some other thing of value. I just finished trying that case. We were successful, but nevertheless, it could become a problem. So be careful about referral fees and be very, very careful about gift cards and other things from somebody that's in the whole RESPA world. And then lastly, the MLS is very, very concerned about misuse of expired listings and people mining expired listings. So I've got 41 questions here. I don't know if I can answer them all, but I guess we'll give it a shot. So let's, sellers did not disclose that final permits on pool construction were not filed with Riverside County, would not use solar permit until pool is complete. So buyers had to pay and make modifications to property for final permit. What are your thoughts? My thoughts are I don't have enough information about it. But bottom line is if you don't have permits, the SPQ and the TDS have places for you to disclose that. You have to disclose that. If you don't have permits for something, or if something, even if something was built per code, but without proper permits, the seller needs to disclose that. If the seller knows what the seller knows, right? What is the purpose of calling out this list of liabilities if you are not going to address the solution? That's actually a great question. I just want to point you in that direction. We're going to be doing this brown bag again, and we're not going to have 40 forms to talk about. So what I want to do is the next time go into a little more liability. I wanted to bring your attention to the fact that these are areas we're starting to see where we're getting calls again. We haven't seen like do not call issues, and but that's a legitimate question. I guess I whetted your appetite, and just be careful. And if you're in one of those issues, just be aware that there may be some problems. All right, let's see if I've got any new questions. Let's see here. Okay, this is a question I get all the time too. I don't know who wrote this question, but Lisa wrote this. So here's the deal, Lisa. So the question is, if there's a change to the TDS, is the best business practice for the seller to correct and initial the TDS or to draw an addendum? And again, it depends. My general answer would be, if it's something small, maybe something that would have been on the TDS and you answered no, comes up during escrow, you can use the addendum form, and there's a box where you check off that you're modifying the TDS, and you can do it right there. So you don't really need to redo the entire TDS. But if it's something significant that your seller finally comes clean about, that's really your call. But generally speaking, it's been set up to where you can use that amendment form, not the extension of time, but the actual just called amendment, right? Or addendum form to actually modify the TDS. Another case that I got recently that I want to bring to your attention that Lisa reminds me of, but she didn't ask about, but she reminds me of, is this. If the rule is that the right to rescind that the buyer has lasts for 3 to 5 days after delivery of a completed TDS. And I had a case a couple weeks ago where the seller sent the buyer's agent, everything was correct, right? Just delivered to the seller's agent, which is a proper way to do it, the TDS, but in that article or that third section where it talks about what you saw in your reasonably competent diligent inspection, it said avid form to follow. That is not a completed TDS, and the buyer retains the right to cancel until that avid form is provided. And it doesn't have to be an avid form. It has to be a reasonably competent diligent visual inspection of accessible areas. You guys understand that? You can't send a partial TDS it is not considered to be complete. And but once it's completed and it's delivered to the buyer's agent, it is considered completed, and the 3 to 5 days starts to run. Okay. See what else I got here. Is it a good idea to have current property owners sign new documents and send to current tenants, or only when we get new tenants? That's a great question. I don't, if you've never done it before, think about it. Is there a reason to do it now? If not, it's pretty much been set up for new tenants. Debbie, that's a great question. I would, me, I'm a paranoid dude. And so for me, the more disclosure you do, the better off you're going to be. But I don't know that it's mandatory that you go back and resend all these forms after the tenant's been there for a while. I don't see the need. But it's a great question. I think I'll do a little research on that. Mass is here. Thank you. But can I get a little more clarity on what is it? The S. Which one is I can't remember which one is the SPBB. Which one is that? Somebody tell me and I'll answer that question. And I get a little more clarity. I don't know which one that is. But in the meantime, I'll answer some of these others. If you could please type that in. I have a question on the RLAS form. Can we give free rent to the sellers by collecting it and giving it back? Yeah, I don't see any reason why you can't. Anybody have an objection to that? Basically, you can rebate everything, right? You don't have to. And it's up to your seller, obviously. You're not going to do it. Your seller's going to do it, probably through escrow. Also, what is the max penalty I can charge for not vacating? I don't know. There's a bill that's going through the legislature right now. I don't know maybe Adam knows about lowering your ability to charge 2 months deposit down to 1 month. That bill is pending. It already exists if you're in the military. So I would suggest a month. And the reason I say that is because if they don't move out on the day they're supposed to move out, you got a month to figure out what you're going to do, and you have that money in the bank. 2 months, you can make it a 2-month deposit and try that. But be aware, though, that there is a bill. We'll keep you posted, but that bill does reduce the deposit down to 1 month for most transactions, unless the building is furnished. Question on there, okay, you've answered it.
John, real quick, that 1 month is furnished or unfurnished.
Is it? Okay, they changed that because originally it was introduced as one or the other. So keep in mind, they're making it hell for landlords in California. I feel, one of the reasons I'm here in Tennessee is I started out just transferring anything that I had in the rental property here just to escape what I could see coming. How do I put that in the RLS form? You're gonna probably have to do it on an addendum. I don't think there's a space for it. I still don't get the appraisal gap, and many of my colleagues have a difference of opinion. In paragraph 1C, okay, Barbara, I hate when you ask questions because they're always tough questions. It says the gap shall be deducted from the final contract price to create the final appraisal. I'm not really sure what you're asking because I haven't had this situation come up. The purpose of the form was that I'm making an offer of $800,000, but I've indicated in that particular portion of the matrix, I'm willing to pay $25,000 over the appraised value. I'm not increasing my offer, still $800,000, but if it comes back at $775,000, we're good to go. That contingency has been deemed satisfied. But then if Barbara comes back and counters at $825,000, the gap of $25,000 remains the same. I'm not sure if that answers the question. Barbara, you and I will chat. I'm not really sure what you're asking there, but that's really what the purpose of the change was. And I don't know what BCO, which form is that? Says that the gap shall be deducted. I'm not familiar with. I don't memorize these form numbers, so you're gonna have to tell me which form that is, and then I can tell you what I think. I agree with Barbara. Our agents are so confused by when being. Well, let me take a look at it, and I'll send out an email, and then Connie can post it on the website. Is there a specific section there unless I can include the clause of not vacant? Well, there's a clause that talks about when you're supposed to be out. So a breach of that clause can be placed in, there's a section on other, right? Or if you can't fit it in there, then put it on the addendum and you can fill it out there. I don't know if Debbie, that's how you do it, but that's, how I would think you could do it. I'm a manager of, okay. The SBSA is always required. I don't have a problem with that thing, with things being required. Again, your broker can decide how much he doesn't want to be sued. Animal teams, question. No, there's two separate forms. One is for teams and the other is for animals. Now, some teams I've seen are animals, but that's not what the form is for. Okay. What constitute whether it is an addendum or an amendment, whether you speak Latin or not. Really, I mean, that's it. I mean, an addendum is a form, is an amendment. We use, lawyers talking a lot of Latin so we can charge you more money. The fact of it is that an addendum is an amendment. They just changed it to clarify, make it easier for people to understand, right? There is a bill, and I hope it passes, where they're going to create a group like they did a couple of years ago and go through all the lease and property management stuff so that everything is going to be called the same thing. In other words, it's not a landlord or a residential real estate owner or this or that or a lease or a rental agreement. They're going to try and clarify so that the language is more consistent with each other. So here it says that an ADM is a new disclosure. Okay, that is correct. So let's say I call Susan, I say, hey, Susan, I have something that I need to disclose that wasn't on the original TDS. That does restart the 3 to 5 days. That is correct. I'm sorry if I didn't clarify that. That is correct. But it is again, so you're going to run that risk, but would you rather risk 3 to 5 days of a right to cancel, or would you rather risk a lawsuit if the party claims that there was non-disclosure? So it just seems to me that you don't have much of a choice there. Thank you, Aaron, for your compliment. I appreciate it. It's Friday somewhere. I know Jimmy Buffett and Alan Jackson are correct. I'm calling you about the gap. I appreciate that. You have my cell phone number. Don't call this afternoon. Call sometime tomorrow after 11 o'clock your time. I'm calling you about the gap. Okay, so that's good. What about property managers that are letting prospective tenants have access to the house using, I'm not familiar with Rently or Show Mojo, or here's the bottom line. The client should tell you how they want access, but you should always protect the client's best interest, right? Article 1 of the Code of Ethics says you should always protect the client's best interest. You don't let people wander into houses. I had a case out in Palm Springs many years ago, where my client was sitting in an open house and he stayed with the husband, who's purportedly a lawyer. They'd actually rented an Escalade, which was a really big deal at that time, drove up to the property, high end. And while he was with the female, the male wandered about the house on his own, stole the identity of the people that were selling the house, and caused quite a bit of damage. So you never should allow people to go unaccompanied through a house, or you run the risk of having a claim. But I'm not familiar with, I'm not a techie guy, so I don't know about these different things. I can find out. I'm not aware of what those are. What is the purpose of calling out this? Okay, you've already chastised me for that. Buyer submits over asking cash offer. Listing agent wanted to wait several days to get all offers in. It depends. Several days later, Collins said they accepted another offer, never even sent counteroffer. Here's the rule. Under Article 1, Standard Practice 1-16, you are required to disclose, provide all offers objectively as soon as practical. unless the seller has said, hold all the offers and I'll look at them all at the same time. Additionally, with the transmission of your offer, under standard of practice 1-7, you can say to the seller's agent, please confirm in writing that you have submitted this offer to the seller. And if the listing agent fails to do that, then you may file an ethics complaint for failing to do that. That's under Article 1 of the Code of Ethics. More than likely, based on this scenario, what ended up happening there is, and I don't know, it'd be interesting to find out, was the selling office, the listing office, did they double end that deal? Because if they did, there's a good possibility that not only is it an ethics complaint, it may be a DRE violation, and the DRE is charged not with protecting your commission, but with protecting the public, and they will go after that agent if it's established, in fact, that the agent held back transactions without the seller's permission so that they could double end the deal. You're surprised how many people complained of the DRE. I didn't know I was offered more money, right? So that is an issue that comes up at the Department of Real Estate quite often. On the TDS, I see a lot of agents check the box, avid attached, and they don't actually send the avid with disclosures. Well, then it's not a completed. There's two breaches there. One is under 2079 of the Civil Code, you have an affirmative duty to do a reasonably competent, diligent inspection. That's on the buyer side and the seller side. So if you fail to do that, it's a breach of your obligation. It also creates an incomplete TDS. So I don't know what else I can say, but you're putting yourself in harm's way, and you shouldn't blame the legal profession when people do stupid things like that, because it's really the people doing stupid things like that that are getting everybody in trouble. All right, let's see here. SPBB is the form you were describing. Oh, okay. So what was the question again, Susan? I can go and find it.
I can just make it quick if you want me to.
Go ahead, please.
So I just want to make sure I'm reading it correctly. So obviously, if you check that box on the RPA, that means you do have number one, you do have a BRBC in place. You have signed. So for example, if I have a BRBC that's at 3%, I would write 3% on number one. Then number two, if it's on the MLS is being offered at 2%, line number two, I would fill in 2%. And then on line number three, we're asking the seller to pay 3%. So is that how it works?
So no, the seller would make up the gap of 1%.
Okay.
Getting the 2%.
Oh, okay. So that was my question. Okay. So you had three. So line one would be a 3%. Line two would say 2% because that's what's offered in the MLS. And line number three would be 1% because that's the gap of the 2%. Is that?
And what you're basically saying is that the buyer is obligated to pay this 1%. We're asking you to cover that. And now the seller can decide, well, I'll do that, but I'm making no repairs. Don't ask for requests for repairs. Or I'll do that as part of this, or no, I'm countering it out. We will not do that. Now you have to figure it out. I'm gonna look at the form and make sure that, because again, I haven't memorized these forms yet. These are all new to me as well. But let me see if I can dig it out while I'm looking to see if there's any more questions. But that's the way I have been told it's supposed to work. And it should be rare. That's not going to come up all the time, but it could periodically come up. Let me look real quick. It's a really good question.
But yeah, I figured out since I'm teaching the buyer's class on Tuesday, I can touch on this a little bit there as well.
Why should I help you?
You give me my great information. Anyway, okay.
Yeah, what they're, and again, I was just looking at the explanation that they sent us. What they're saying is the purpose is not to give double compensation. The purpose is to make up the gap. So all you're doing is filling in the box correctly to make up the gap or a portion of it. Maybe the buyer's saying, you know what, I don't have 1%. I have 0.5%. So see if you'll make up 0.5%. Again, it's going to work differently because all of you have different transactions that you need to deal with. So that's that. Okay.
Okay, thank you.
Thank you, Christy, for the compliment. Thank you, Debbie, for the compliment. And whoever owner is, I know you're confused. I don't know why. So I think we've covered everybody's questions. If I have not, send me an email. It's jvg@tylerbursch.com. The website is www.tylerbursch.com. If it's not about real estate, we have other lawyers, and our blatant commercial billboard is sitting up there right now. So ask away. We're not a hotline, however. So call the hotline. And Adam, once Connie gives me the go ahead, I want to sit down with you and go over who's going to be on our first legal panel. And we'll got a couple of names for you. I'd like to ask Ed, because so much is going on in the well, let me ask you guys, send me an email. What subject matter on a legal panel would you like? Adam's going to be the moderator. What kind of subjects would you like me to cover? And who should I, I'll figure out who I can invite, and, subject to Connie's okay, we'll get them on board. It'll be a Zoom class because nobody's going to fly into Temecula to do a program for free. So think about who you want. In the meantime, we'll get all that ready to go. And I think I've gone way over my time. Oh, yes, I have. Oh, yes, I have. But that's okay, right? Thank you all for sticking around. Got a whole bunch of people today. I really appreciate your coming. And we'll see you the next time we do a brown bag. I don't know if it's on the calendar yet. I'm hoping to come in and do it live, which means I'll have to wear long pants, which means I'll have to get my long pants cleaned. So thank you.